I was pleased to speak a moment ago here in the French Cour de cassation on the role of proof in private damages actions. I spoke about the position in the CAT in terms of getting evidence from defendants and third parties in the light of the Bacar case, the judgment of the European Court. In my view, the position in the CAT is very similar to that set out by the Court of Justice. First, we have very extensive powers of active case management, particularly those in Regulation 53, and also in light of our general principles governing all actions in the court, particularly requiring us to actively manage a case and to do so at proportionate cost. The second point were really two issues that arose concerning the binding nature of a decision of the Commission and or national competition authorities which was discussed in the Repsol case, and I discussed two aspects to that. First, this is what leads to us having a bifurcation between follow-on actions, which follow decisions which are binding on the court, on the parties, and so-called standalone actions. That's particularly where parties want the damages to cover a longer period, for example, or to cover a broader range of products and services. Good examples in the CAT would be the MIF, the multilateral interchange fee cases, or indeed the trucks cases. And the second aspect coming out of following on from the Repsol case that interested me was the potential issues arising as a result of Brexit. In brief, before Brexit, the decisions of the Commission were binding on the parties in private damages actions before us in the CAT. But post-Brexit, these decisions will eventually be non-binding but could provide relevant evidence. And I briefly discussed the difficult situation which we may have at the moment in the transitional period and illustrated by reference to the farmed salmon case which came to the court, the CAT, only last month. Third point which I mentioned was a discussion of the importance of and how we deal with economic evidence in the CAT. A few points specific to the CAT. We are a specialist tribunal. We will have a range of expertise on a tribunal, and we'll always have an economist on the panel in a follow-on damages actions. That means we're particularly well placed to evaluate economic evidence, and I spoke briefly about hot tubs where we put all the experts together and they're quizzed by us, particularly the economist, at the same time. I also spoke about the importance of looking at the evidence in the round. Don't just focus on the quantitative evidence presented, but look at it in the round, taking into account all the evidence, in particular the qualitative evidence, and made reference there to the Britnet case. I made reference to the broad axe principle, a long-established principle of English or common law, which is now very much reflected in the Damages Directive in Article 17. And I mentioned the court's approach to disclosure in the leading cases of trucks before us. And the final point, given that it's so specific to the common law system, I explained the importance of cross-examination in cases before us, which is very well illustrated by the recent hydrocortisone decision with which I was involved, and we wait to see what the Court of Appeal has to say about that. Thank you.